Start with the 56th District Court, Judge Cox. You're first up with your 3 minutes to give your introduction, Judge.
I'm Lonnie Cox. I'm the 3-term Republican judge of the 56th District Court, but I shouldn't have to tell you that. I've been an associate member of this club for 13 years. Ronald Reagan's first commandment was, "Thou shalt not speak ill of Republicans." My opponents recently sent letters throughout the county calling me every name in the book. And depending on who you talk to, he's probably right. Many of the people that I've sent to prison or have lost in court or in the Court of Appeals, they don't like me, and they sometimes call me names. That's music to my ears, as it should be to you, because I'm fulfilling my first 2 campaign promises, being fair but firm and following the law. He also said that I left the DA's office after being demoted.
Pardon me, Judge. I'm sorry to do this, sir, but as we pointed out, the rules of the game. No personal attacks against
I'm
your
not
opponent.
attacking him. I'm responding to
When you
his...
say your opponent, sir,
Okay.
that's the rules of the forum. I'm sorry, Judge. I know this is a prepared speech.
May I
but
keep
those are
going?
the rules. Yes, sir.
All of you know why I left the DA's office. You elected me to be the first Republican judge of the 56th District Court. Before that, I was the chief prosecutor in the 212th District Court for 2 years. Before that, I was the chief of the misdemeanor section for 2 years. Some people call it a demotion, but everybody knows it was a promotion with a $15,000 raise. I've been accused of taking donations from liberal trial attorneys, like that's never happened to other people in the race. For that to be said and call it bribery is insulting to all judges. There's been a complaint that I've spent over $500,000, or that $500,000 has been spent on a constitutional lawsuit. It's not a frivolous lawsuit. It's a suit that has ramifications throughout the state. I didn't start it, but I am here to finish it. I haven't appealed it 4 times, and I haven't lost any of the motions. We need to stop that. But only you can stop the forest fire of frivolous spending. Finally, I've been in this race, and my opponent had a STEP program. And in his STEP program, he took convicted felons and gave them chances on probation, even after they violated their probation. I hold probationers accountable. My push cards are on the table. You can see all of my law enforcement and conservative PAC endorsements. Add to that the endorsement of Cheryl Johnson and Joe Giusti. Finally, I do not have any names for my opponent. But the
Judge,
Republican National Committee
your
calls
time
him
is
a
now
hard Democrat.
I'm sorry, Judge.
That's all right.
Again, these are the rules that were set beforehand. The candidates agreed to, sir. And I'm sorry, Judge, but the next time any reference to your opponent in any way, as we said in the rules, I have to ask you to step away from the podium. All right, sir? I just want to make sure. I don't want it to be combative, but those were the rules that everyone agreed to before we came in here today. Let's do that. All right, up next, the challenger, former Judge Wayne Mallia. Wayne?
Good evening, everybody. My name is Judge Wayne Mallia. I think there are 4 very important issues for you to look at in this race. First, experience. Second, judicial temperament. Third, morals and ethics. And 4th, vision. I've been a resident of Galveston County for over 50 years now. I'm the 4th generation to call Galveston County home. 17 of my 20 years of education have been in Catholic schools. I've been married to my very beautiful wife, Sherry, for 24 years. We have 2 wonderful children, Corey, 21 years old, Madeline, 17 years old. I came straight back home to Galveston County right out of law school to serve you in the District Attorney's Office for 13 years. I worked my way up through the ranks of the District Attorney's Office very quickly through hard work and perseverance. In just a little over 4 years, I was promoted to the highest appointed position in the office, First Assistant, where I helped run the office, supervise the attorneys, and prosecuting the most serious cases that came through the office. I took some very dangerous criminals off your streets. As a matter of fact, I was Lonnie Cox's supervisor in the District Attorney's Office. After that, I served you faithfully for 12 years as a District Court Judge. The last 3 years, I've been a Senior District Court Judge. Over all those years, I've earned the reputation of being a very, very fair impartial, and hardworking judge who treats everybody with dignity and respect, both inside and outside the courtroom. I think it's very important to note that I have 4 more very valuable judicial years of experience than Lonnie. I also have many more years of legal experience. I promise you that if I'm elected, I will vehemently support and utilize our drug court and veterans court. I was the first judge to bring the STEP program to Galveston County. The STEP program is a drug court program. I also helped create the drug court program. The drug court program is legislatively mandated by the legislature. We have to have it. The drug court program and the STEP program also have laid the foundation for veterans court. These programs are nationally recognized as being effective and efficient ways to get non-violent probationers the rehabilitation they need to become productive citizens, instead of wasting valuable tax dollars and money in antiquated revolving door methods. These types of programs are also encouraged and supported by the National Conservative think tank Right on Crime. I'm very proud to be one of the many ranks of Republicans who have switched parties. High Republicans like Ronald Reagan, even Governor Rick Perry, and even locally, Lonnie Cox switched parties. I'm endorsed by Texas Right to Life, who recognize my very conservative values. They recognize my superior judicial and legal experience. They recognize my superior judicial temperament, my superior ethics, and superior vision.
Now, from the 405th District Court, Judge Michelle Slaughter. Judge, you'll have 3 minutes.
Good evening, everyone. I'm Michelle Slaughter. I'm your judge in the 405th District Court. I am the real Republican and the only conservative for judge in the 405th District Court. For those of you who do not know me, I was elected in 2012. I took the bench on January 1st of 2013. Upon taking office in 2013, I inherited the most inefficient district court in Galveston County. Efficiency had dropped for 6 years straight in that court. I also inherited the biggest backlog docket in Galveston County, yet I excelled. Within my first year on the bench, I took the biggest backlog in Galveston County and turned it into the second lowest backlog in Galveston County. And again, that's my first year in office. I turned the 405th from the most inefficient district court in Galveston County to now being the most efficient district court in Galveston County. I have fulfilled every campaign promise I made in 2012. The 405th is now the most efficient and most effective district court in Galveston County, and I have ensured that justice is served. In criminal cases, I scrutinize plea deals. I ask questions to make sure that the plea deals are in the interest of justice. Sometimes justice is a lockdown rehab facility to break the cycle of criminal activity, and other times it's sentencing a child predator to 99 years in prison. I want to ensure that justice is done. If it was just about efficiency, I would rubber stamp all plea deals. The state legislature requires that judges accept or reject plea deals because the judge is the one to be trusted to ensure that justice is served. We shouldn't blindly trust all the lawyers. In civil cases, I refuse to give frivolous continuances. I quickly dispose of frivolous lawsuits, and when appropriate, I sanction attorneys and parties that bring frivolous lawsuits. Most importantly, I know civil law. Civil law is the most complex area of the law. I spent years at 2 large international law firms representing Fortune 500 companies, and I litigated cases across the country in state and federal courts. My hard work on the bench and my tough but fair demeanor has earned me dozens of endorsements. You can find those endorsements on judgemichelleslaughter.com, and those include every law enforcement agency that has endorsed in this county has endorsed me. I would love your support, your help, and your vote to keep me as your judge of the 405th District Court. Thank you.
Thanks, Judge. And the challenger in the 405th District Court, Attorney T. Philip Washington.
Good afternoon, everyone. I'm T. Philip Washington, and I'm here to ask for your support and your vote in the March primary to become your next judge of the 405th District Court. I have worked the past 5.5 years as a prosecutor at our Galveston DA's office. I've worked my way through the trenches, through the misdemeanor courts, the juvenile courts, as well as through the felony courts to my current position as a senior felony prosecutor. That means that if you think of a case between DWIs and murders, I've tried those cases. I'm asking for your support based on my proven track record and the experience that I bring to the table. Prior to beginning law as a second career, I worked for 9.5 years as a K-12 teacher and as a collegiate administrator and instructor. What that means, ladies and gentlemen, is that I know and understand people. My graduate studies were based on human development. It allows me to have the judicial temperament to understand the bigger picture. And we have to understand that picture if we are to sit in a position in which we decide what is justice. What does that fluid concept mean in each case that comes before us? We run a very grave risk if we allow our performance measure to be simply numbers. Which court has the lowest numbers? Which court has moved the most cases? Because judges are sworn in to see that justice is done. And the bottom line, ladies and gentlemen, is that you absolutely, positively, and unequivocally cannot have efficiency if you don't have justice. I have a 3-pronged program in which I plan to bring as your judge. I will save tax dollars by being present to hear every single case that is tried in that court. I will have the backs of our veterans by ensuring that if there is a veteran who is eligible to participate in our Veterans Treatment Program, our court, I will ensure that they're able to transfer that case from the 405th to the Veterans Court. I'm also a former drug court prosecutor because I understand that with our individuals, we have some people who just do dumb things. And with those individuals who do dumb things, we need to give them the opportunity to straighten their lives up and to become contributive members of society. You can be tough on crime by doing the right thing at the right time. And the right time is all the time, ladies and gentlemen. And third and foremost, I'm going to have the backs of our victims. I'm going to make certain that if a person desires to have their day in court, meaning a trial case, they get that opportunity. Because if we don't do that, if we participate in things like rocket dockets, etc., we short sell those cases, we don't give prosecutors the benefit to see that justice is done, and we send a unremarkably bad message to our police officers, our men and women in uniforms, who get up every morning and risk their lives to protect us. That is why I come to you, I ask for your vote, I ask for your support, and I hope that throughout this forum tonight, you get an opportunity to know me a little bit better, to know about my experience, my values, and my philosophies.
Thank you, Phil. All right, and this first question I'm asking will be for all 4 of you. Phil will answer it first, then Judge Slaughter, then we'll go with former Judge Mallia, and then Judge Cox to wrap up. And so let's go ahead and start off with this. What's your opinion about probation versus incarceration, and more importantly, what goes into your mindset as a judge, whether through the actions you already have taken or as you would approach it in the court when considering probation settlement or plea bargain versus an actual conviction or action by the court. Forgive me, the mic's throwing us off here. So 3 minutes, sir.
Yes, sir. In law school, I had a wonderful opportunity to take a criminal corrections seminar from a gentleman by the name of Larry Gist. Pretty smart guy. They actually have a jail named after him in Beaumont. During that course, he told us about what we call NORPs, normal, ordinary, responsible people. People who may go out, have a bad day or a bad week and do something dumb and become entrenched in the criminal justice system. For those individuals going through the process of getting arrested, finding out, having to show up to court day in and day out, or month in and month out, is enough to scare them straight, and we never have to see those individuals again. That's where probation becomes important. We give them the opportunity to realize what is the cause of their issue, and allow them to participate in services that will allow them to put together positive methodologies so that they can keep themselves on the straight and narrow. That's the overwhelming majority of individuals we see in our courts. Unfortunately, there are some monsters out there. Individuals who sexually assault kids, individuals who don't know how to use their words instead of their hands, and they bludgeon each other, pull guns out on each other. Those are monsters, and those are the folks that we have to go after very hard. Those are the individuals that, when we look at the actions that they brought to the table, when we look at their criminal histories, those are the individuals that we need to put in jail and to put them in there for a long period of time, because the bottom line is that the chances of them rehabilitating themselves, the chances of them assimilating or reassimilating themselves back into society are slim to nil. We talk about justice, and it's a fluid concept. It changes from case to case. Even if it's ag assault with a deadly weapon and another ag assault with a deadly weapon, the independent facts of those particular cases are going to decide what's the right thing to do. And that's where judicial temperament becomes so gravely important, and the trust factor. Trusting the learned individuals that practice in the court, the prosecutors who are working day in and day out to work with the police, to work with the victims, to decide what evidence is there and decide what are the proper offers to make on those particular cases. Likewise, the defense bar, because each person is represented by a defense attorney, and that person gets all of the evidence from the case from the prosecutor. If we get into a situation where those individuals have had what we call a meeting of the minds, meaning the state says this is the reasonable offer we're making, and that defendant decides, I'm going to accept responsibility, that's a reasonable offer, I want to take it. When they present it to that judge, the judge should take it. It's not a blind acceptance, it's an acceptance based on the working relationship with the parties that are in that court on a daily basis, and knowing that they, the police, the defense attorneys, and the prosecutors would not bring anything to the court that would harm us as taxpaying members of this society and this county. It's not a blind acceptance. We have to trust those practitioners. Now, on the back end, when the judge is actually privy to the facts, as if a person is already on probation and they do something to violate that probation. Thank you.
Thank you.
All right, probation versus incarceration is always going to be a very, very fact-intensive situation. You need to know as many of the details as possible, because obviously we've got two pillars to our justice system. We've got, in criminal justice, we've got rehabilitation to try and rehabilitate someone and make them into productive members of our society. And we have the punishment aspect, where someone does wrong, they also need to be punished. Now, it depends on the facts of a case as to which one weighs more heavily in that particular case. Certainly, when you have repeat offenders, things like punishment are typically more in line with repeat offenders, as well as with violent offenders. That's when you want to look at more closely at the punishment aspect of that. Now, when you have people who are suffering from drug addictions, who are committing crimes because they are drug addicted and haven't received help but want help, those are the people that you can rehabilitate. And you want to try and get them into drug rehab facilities and drug rehab programs. And we even have lockdown drug rehab programs through the Texas Department of Criminal Justice. And often I send folks to those lockdown facilities to get them that intensive treatment that they need, because they've struggled with drug addiction for so long. So those folks can definitely benefit from the rehabilitation aspect of it. Now, when I do send people to prison, I often talk to them about prison ministries, because even though they are being punished and going to prison, I try to encourage them that if it is within their own personal religious beliefs, that they should seek out the prison ministries, because those prison ministries do incredible things for the folks who seek them out and get involved with them. The recidivism rate is so low for people who get involved with prison ministry, so I always try to encourage that to, again, try to break the cycle and make them turn their lives around, so that when they get out of prison, they lead a more productive life. So again, there's a lot of factors that go into it. It's always a very fact-intensive situation, and so I listen carefully to the facts before I make up my mind which one is more appropriate, the rehabilitation aspect or the punishment aspect. Thank you.
Thank you, Judge.
Unfortunately, when I come in situations when I'm making that decision, I'm able to draw on my prior experience, and I am the most experienced candidate up here in criminal law, where I earned that grade through very hard work with the District Attorney's Office for 13 years. Again, 8 of those years I was the first assistant where I prosecuted the most serious cases that came through the office. So I depend a lot on drawing on that very valuable experience in making those type of decisions. Of course, when you're making, back up a little bit, also based on that experience in the District Attorney's Office, I tried over 65 felony criminal cases to juries. That included 20 murder and capital murder cases. You always want to look at in those situations, you want to look at the nature of the offense, the circumstances of the offense. You want to look at the criminal history of the offender, and then come to some type of conclusion about what would not only be best for the offender, but what would be best for the victim and society. Always weighing in on these decisions, you want to protect society, and society deserves to be protected, especially from violent offenders. And I'm not, have no qualms at all by, of giving very lengthy sentences to violent offenders, and I have a record of that when it is appropriate. I've given life sentences. I've even stacked 50-year sentences on life sentences when I think the circumstances warranted. When it comes to probation, I think it's usually going to go, in my mind, it's going to go to a non-violent, non-repeat offender. And also, when I'm considering probation, I want to look at the options that I can give that probationer to make sure that they successfully complete their probation and become a productive citizen in our society. That way, they're not draining our very limited resources in our prison system, and they're saving you money as taxpayers. That's why I brought the STEP program to Galveston County. Again, the STEP program is the same thing as a drug court. It's mandated now by the legislature. Galveston County has to have a drug court, and I paved the way so we could easily transition into a drug court, and then I laid the foundation so that we could have a veterans court. These programs are very, the judge becomes very involved in all the probationers that go through these programs. The probationer has to report to the judge at least once a month with the probation officer, for the probation officer to update the judge on how well that probationer is doing. And at that moment, the judge determines what type of sanctions, if necessary, to give the probationer if they're violating technical conditions like not paying fees, not doing community service hours, and things of that nature. Or if the probationer is doing well, the judge will compliment the probationer and encourage them to keep doing better and remind the probationer, we're here to see you successfully complete probation so that you can become a productive citizen in our society and not drain your tax dollars.
Time, sir. Thank you.
Probation is a wonderful tool. We use it probably more than any other tool in the justice system. But when we use probation, we almost always use it for non-violent offenses, and we certainly try to use it only for people who haven't gotten probation before. Our probation department has some great tools. So they use these tools to evaluate the people that go on probation. We know that everybody will not do well on probation, but we need to at least try. We need to at least try to rehab people who can be rehabilitated before we try to lock them up. But when probationers don't participate, or when they commit new crimes, well, we need to revoke them. We need to send them off. And I'm one of the strictest judges in the county on that, because when we keep trying to fix people who won't be fixed, we're wasting your money. Conditions of probation are such that one size does not fit all. And so while I was chief prosecutor for the entire misdemeanor section, while I was chief in the 56th District Court, I watched over more than just my cases. I watched over the cases of the people that worked under me. And I found that by looking at these defendants, listening to their history, talking to the probation department, looking at what the prosecutors have and what the defense attorneys have, we can do a lot to make these people better people. We can bring them back into society. We don't have to throw them all away.
This goes into talking about judicial fairness for both sides. If you observed a party in your courtroom being poorly represented by ineffective or inexperienced attorneys, how do you handle such a situation? 3 minutes, Judge Cox.
First thing you have to do, you need to meet with that attorney. It's not unusual. Don't do it in the courtroom. Don't strike them down in the middle of the courtroom. You bring them back into the chambers and find out if there is a reason for their participation and the way they're acting in the case. Sometimes they have a good reason. Sometimes you can work with them to improve that. But sometimes they're just not quite fit. What we try to do on the appointment of cases, for example, we have good people that we appoint to these cases. They have high criteria in order to be on the list of court-appointed attorneys. And we evaluate that. We're pretty active about when we find an attorney not doing a good job. Well, then not only do we talk to that attorney and find out why they're not doing a good job, but as judges, we meet together and talk about, we do it in our judges meetings, and we talk about these attorneys and find out if there are other courts having the same problem. So start with the defendant's attorney, see if we can fix it. But if we can't fix it, sometimes we have to move on. The defendants have the right to ask for another attorney. It's something that we take pretty seriously. We don't like to change them in and change them out because it just takes more time. It keeps them either locked up or it keeps them under the problems of being accused as a criminal. Both of those things we like to eliminate.
Of course, it does depend on the degree of the ineffective assistance of counsel. The best scenario, you would hope that the defendant would file some type of a motion or request the court to address the matter, to have the attorney dismissed or have another attorney appointed for the case. That makes your job a whole lot easier because you have the defendant asking the court to step in and make a decision. And if that were to occur, if there was a motion filed where the defendant made a request to have a hearing on that topic, of course, as the judge, you listen to both sides. You listen to the defendant's side, you listen to the attorney's side. And over my many years of experience, most of the times when a defendant does ask to have a defense attorney dismissed, it's based on a misunderstanding that the defendant thinks that that particular defendant knows the law, and they really don't know the law. So after you hear the attorney's explanation, it's really mute, and you just explain to the defendant, you know, your attorney's right. What you're saying is the law is not the law, and your attorney is doing what he or she can do on your case. On other circumstances, sometimes the defendants do have a point, and it's easy in those circumstances to say, well, I think it's best under these circumstances, Mr. Attorney, for me to dismiss you, and I'll just appoint another attorney on the case who can start working on the case. Also, that way, if there's the defendant's that upset with the attorney, and you appoint a new attorney, you're reducing the possibility of the defendant wanting to appeal that case if there's a conviction on the case. You're also not setting yourself up to get reversed on appeal due to ineffective assistance of counsel. Now, if the defendant doesn't file a motion or ask a hearing before the court, as a judge, I have to just evaluate how serious the situation is. If it's not very serious, and I would pull the attorney aside and say, you know, what's going on here? Maybe there's a logical explanation. He's having family difficulties or some other difficulty that's taking his or her mind off their job, and then you can say, well, I tell you what, let's continue the case, let you take care of what you need to take care of, get your mind straight, and let's step forward. If it's a real serious problem, of course, I think the judge is obligated to step in and talk to the attorney and see about resolving it as smoothly as possible by pointing out to the attorney that maybe he's not the best attorney on that particular case for that particular defendant.
Well, first of all, if I actually witness true ineffective assistance of counsel and they're a court-appointed attorney, you can guarantee that I will not appoint that attorney on any other cases. Now, if what I try to do is if I have a sense that there might be an issue, maybe there's a lack of communication or something going on where maybe the defendant isn't getting the type of counsel he or she needs, then what I typically will do is ask a lot of questions of the defendant. I will, to make sure that that defendant understands what's going on, understands the process, understands what they're facing. For instance, when we do plea deals, we ask a whole series of questions to make sure that that defendant knows what he or she is agreeing to with part of the plea deal and knowing what their options are. In addition, you know, I'll a lot of times explain procedures to defendants and see if they have some recognition of what's going on and make sure their attorney has spoken to them about the process, about what's happening. Now, I certainly have called attorneys up to the bench and quietly asked them, you know, is this, you know, part of your trial strategy? Because on occasion, they have a trial strategy where maybe it looks at first as to be ineffective assistance counsel, but it's actually a trial strategy. And they'll tell me, yes, we've got a trial strategy, this is part of it, and then we can go on from there. Now, in some cases, I've actually had a situation where at the point we're already in trial, we start to see maybe what's ineffective assistance of counsel. And the chief prosecutor of my court is a guy by the name of Matt Shawn. He's very good. I have seen him actually step in and try to do a bit of the defense's work to ensure that things are going to be upheld on appeal if there's no ineffective assistance of counsel. So I've actually seen him do the state's job as well as defense counsel's job to protect the case and to make sure that there is no claim of ineffective assistance of counsel. So that's happened before, and that comes from having a great relationship with the chief prosecutor in the court to have that assurance. So I hope that answers the question, and I think I've taken enough time on that. Thank you.
I learn anything as a classroom teacher, it's to praise in public and admonish in private. Generally, if you give people an opportunity to voice whatever their issue or concern is, you're going to find out a whole lot more than you want to. if we're dealing with ineffective defense attorneys, and it's something that I can see from the bench or something that other practitioners can see as well, that's when you have a private conversation to find out what's going on with that individual. And it's a little similar to when we pick juries and we talk about topical areas. Sometimes folks have something very important to tell us, but they don't want to do it in front of a room of their best new friends. So we afford the defense attorney the opportunity to come in and to talk in private and find out what's going on. If it is something that we can handle together, we will. Can't tell you what the answer is at this point because it's going to depend on the circumstances that we are dealing with. In some cases, we see a broken marriage of sorts in that we have the criminal defendants and the attorneys who cannot get along or not getting along. In those instances, what we've seen happen in courts that's been extremely effective is calling them up to the bench. And once again, Mr. and Mrs. Smith, we understand that you filed a motion or you have complaints against your attorney. What's going on? We noticed that one or two things happen. We either get the floodgates opened and you realize it's an irreconcilable situation, or sometimes they kind of stop and decide, you know what? It was a big issue in the holding cell, but now that the light's on me, I'm realizing it's not that bad. You ask the follow-up question, hey, can y'all move through this and work through this together? A lot of times we'll get the answer of yes. As a prosecutor, I have also learned that, yes, sometimes we have to step up and go above and beyond and do our jobs as well as that of the defense counsel, which means, we give you discovery and 2 weeks later you say, I don't have it, what happened? Go ahead and give that discovery again. If, individuals bring up issues that they're dealing with their clients, and we take those affirmative steps to try to make certain that everything runs seamlessly. It's a pretty straightforward question. I hope my answers have been pretty straightforward. Thank you.
Obviously during election season for a district court judge, a lot of concentration is on the criminal side of the docket. But civil cases are actually a predominant part of the district court cases, so this addresses that. In your opinion, what effect does a case to arbitration or mediation have on the efficiency of a court docket?
Well, certainly, I would say probably around 99% of civil cases can settle in mediation. Actually, very few civil cases actually go to trial. Having been a civil litigator for many years for large international law firms, I litigated cases everywhere. I tell you, mediation is an incredibly effective tool because you've got someone who's a neutral person weighing out both sides and telling you, what your problem areas are that maybe you have blinders on, or maybe it's just your clients have blinders on and can't see it, no matter how much you tell them about what the situation is. Hearing it from a neutral third party sometimes is what finally gets it through to those folks. So it kind of brings a practicality to the situation. Arbitration's a kind of a different scenario. We have laws that can require parties to go to arbitration if there's been an arbitration agreement. And certainly the law favors arbitration to move it out of the court system and into the arbitration system where the parties pay for the procedure and the proceedings and all of that rather than taxpayers having to pay for that. So when there is a legitimate arbitration case that comes before me and someone's seeking to compel arbitration, I send it to arbitration as required by the law. And mediation, I require all cases to mediate unless they have an objection, and it has to be a good objection. It can't be just, oh, we can't agree on this. It's like, well, have you tried talking about it? And I talk to the parties and trying to figure out, really, is it that you just don't get along, or is it that mediation really would be ineffective? But 99% of the time, mediation is effective, and I always require it, and I appoint mediators unless the parties can agree on their own mediator. And we've had a great success rate with that. So typically the cases that go to trial are those that really need to go to trial. So I think that about wraps it up, and I'll go ahead and send it on to the next person.
Thank you, Judge.
There's an interesting article that came out of the American Bar Association's magazine last summer, and it delved into the question of whether or not civil attorneys are doing a disservice to their clients, because now at the initial client meeting, the conversation centers around arbitration, mediation, and other forms of alternative resolution, and that they're not even offering trial as a possibility. Right or wrong, whatever side of it you fall on, it's fine, but I think the very fact that you would have a national publication presenting that question speaks volumes about what attorneys think as far as the benefits of arbitration and mediation. Again, in any case, we're dealing with human nature, and I'm all for any opportunity to put folks in a room together, hopefully with a cup of coffee between them, to be devoid of the emotion and actually to focus on the objectivity. Having that neutral third party, the mediator, to call balls and strikes and timeouts when necessary is very effective. We also look at the number of civil cases that actually go to trial in Galveston County. That number is minuscule compared to when you look at the number of criminal cases, and there's a reason behind it, because when you actually get folks together to, again, take the emotion out of their issues, they can typically work it out. Now, I'm no fool. There are going to be some times that individuals will go together and they'll sit at the table, and before they say good morning, they say, we're at an impasse. And that's it, game over. We get it. Well, the bottom line is we give them that opportunity, we afford them that opportunity. We ask them to take that opportunity seriously, make the best of it. If they can, great. If they can't, we simply allow our judicial system to do what it is, to do what it does, and that's to allow them their day in court if it's not a frivolous lawsuit. Thank you.
Thank you.
Well, I think to start off, it might be helpful to explain the difference between arbitration and mediation. First, arbitration is a more formal process than mediation. Arbitration is less formal than a trial. Arbitration is where you have one person or a panel of people who actually hear evidence, and attorneys present arguments, and the arbitrators will make a decision on the case. Now, sometimes the arbitration can be what we call binding, or it can be non-binding. Usually, when you have an arbitration, it is going to be binding, and usually arbitration cases are pre-decided before the suit is ever filed. It's usually placed in a contract that the parties sign about whether the parties have to go to an arbitration before the case can go to trial. Now, mediation is a much less formal process. It's a confidential process where both parties go to a mediator. The mediator is a neutral person, unbiased in the case, doesn't have a dog in the fight. And the mediator's job there is to try to facilitate an agreement between the two parties. Another good thing about mediation is it's a confidential process. Anything that goes on during the mediation and what is said during mediation cannot go outside of the mediation room or the parties in the mediation. It cannot be used in trial if the case happens to go to trial. That way, both parties are a lot more freer and relaxed about talking and discussing about things without the fear of, if they don't settle it, coming up in trial. I am a huge believer in mediation. I believe in mediation because if the parties are able to resolve their dispute in the mediation, it is the parties who had a part in resolving the dispute, and they're usually a lot more happier with the result than if they go to trial where it's black or white. One side wins, one side doesn't win. I've actually have been a mediator over the last 3 years. When I was a judge, I required most cases to go to mediation before I let them go to trial, and I often, very often, would have attorneys come in my office and say, Judge, look, you're going to waste our time if you send us to mediation. We're just on total opposite ends of the spectrum here. We can't agree about anything. We can't even agree on a mediator. I'll just say, I'm sorry you're going to mediation, and I'll go ahead and appoint a mediator for you to take care of that part of it. And 90% of the time, those attorneys will come back and say, Judge, I can't believe it, but we settled the case. So I'm a huge believer in mediation.
Right.
On TV, Judge Wapner used to say that when people had a problem, then they needed to try to get together and work it out, and if they couldn't work it out, then there was the People's Court. Well, what we mean by work it out is typically for people that get mediators or arbitrators, by personally being the master of all of the TWIA cases in Galveston County, and now all of the BP cases in Galveston County. I know that mediation is something that we have to have. There's 47,000 BP cases. The TWIA cases, many of those go through arbitration, and when they go through arbitration, that settles the cases out. We must mediate and arbitrate where possible. And our mediators are highly qualified. They're good people both here in the county and then slightly outside of the county. Both mediation and arbitration not only saves the parties money, but it really saves the county money. It reduces the amount of time that we spend tied up in trial. It's the most expensive way to handle business when you have to try the case. Well over 98% of all of the civil cases go through mediation and arbitration and are settled out one way or the other. Without mediation and arbitration, all of the courts, and this addresses your question, all of the courts would be locked up. There's no way we could do what we would have to do. I require mediation on all cases, and sometimes in the mediation, they cannot resolve all of the issues. But if they could only resolve some of the issues, you've now narrowed the trial or the dispute down. So a little bit of mediation can go a long way. Like I say, I require on all civil cases.
And this one touches on a lot of what we've been seeing in many years, where national issues, seen in the political spectrum, make their way into the courtroom. Those include same-sex marriage, freedom of speech versus hate speech, challenges in the courts to symbols of the past, logos, names of schools or teams or flags and the like that come into a courtroom at some time. Now, you can't prevent the lawsuits happening, but as a judge, when those things come in, how do you make sure you balance fairness to making sure politics stays out of your court? And we'll start with Philip for your answer on this one, sir. 3 minutes.
Humility. We're charged with a lot of responsibilities each day we come to work, especially as a prosecutor. My upbringing, what I bring to the table, the way that I see the world, naturally, I mean, you don't divorce yourself of those things when you come through the doors or when you pick up a file and when you read it. But on May the 10th, 2010, when I got sworn in as a prosecutor, I was sworn in to see that justice was done. Some of that is fueled by who I am as an individual, but bottom line is that I have to and will follow the law in any case that comes up to me. If there is some issue, and in the 5.5 years I've practiced as a DA, there's not been a situation that's come before me where I felt that, I cannot be fair, firm, and consistent on this. But should that day come, then I owe a duty to the citizens of Galveston County, to myself, my family, to the parties that are in front of me to step away from that matter. Objectivity is what we're charged with, what we have to use on a daily basis. We talk about national issues and folks say, where are you on same-sex or, pro-choice? Hey, my wife and I were blessed to have adopted a beautiful 7-year-old daughter and a wonderful 4-year-old son. So I think it kind of gives you some insight as to where we are and how we feel on those matters. But T stops at the door if the case comes before me. And I can't use my personal experience to guide what happens in that individual case. I won't use my personal experience to guide that, to say that this is how I would approach the situation and this is how you have to. It's a problem if you do. I simply would follow the law, abide by the great Constitution of our wonderful country and our state, and allow the chips to fall where they may. And should that day ever come that I'm not able to do so effectively and adequately, well then I'd have to recuse myself from that particular matter.
Well, the short answer is adherence to the law, strict adherence to the law as it is written and not the way we want it to be. That is the job of a judge, and that is required. That cannot be strayed from. That should never be strayed from. It is critically important. I'm a constitutional conservative. I will always strictly follow the law as it's written. You will never see me legislate from the bench because it is not my job. I'm not a part of the legislative branch. I'm part of the judicial branch. And so you can guarantee that the law as it's written will be upheld. Now, if there are certain situations where I just absolutely cannot be fair, or if there's even a possibility that someone thinks that, she just really can't be fair because she's made this statement or that statement, if that's truly the case, if I feel that that's actually the case, I will recuse myself. I will not allow my personal feelings about a matter interfere with my job or interfere with justice being done. But I absolutely am a constitutional conservative and will never legislate from the bench.
Thank you, Judge.
I think the very important first thing you need to do when you come up with some controversial cases like that make it difficult because of your personal views. The first thing I do is I acknowledge what my personal views are, and I have to make sure that I don't allow those personal views to sway my decision in the case. I think that in those types of cases, especially, or in any case, I believe that preparation is key. I believe it's always been my practice as a judge to read everything in the case that you can read, the motions, the briefs that the attorneys file. I make sure that I read those before any hearings or trials so I'm making a very educated decision in the case. And I've earned a very good reputation of working very hard as a judge and making sure that I do read everything in the case before I make that decision. I agree with most everybody who's talked up here so far, that if the issue is so personal to me that I don't believe that I can set my personal views aside and make a fair and impartial decision in the case, then I will recuse myself and leave it up to a judge who he or she believes that they don't have the strong personal beliefs that I have and can make a fair and impartial decision in the case.
And so I am the judge. I'm the administrative judge that when one of these other judges has a conflict, they come to me. They tell me what their conflict is. And if they need someone else to take the case, then I sort that case out and give it assigned to a different judge. But keep in mind, judges are people too, and we do have our conflicts, and sometimes we do need to go to the administrative judge and say, hey, trade me out, give this to someone else who doesn't have the same problem. Usually the problem is that we know somebody who's on one side or the other, which makes it very hard for us to try the case. You talked a little bit about politics, and of course politics has no place in the courtroom. Republicans or Democrats or independents or any other class of people, they all deserve justice. And in fact, if they don't get justice, then you're not getting justice at all. So all of us deserve that justice. I've never been recused, but I have on occasion asked the administrative judge when I wasn't to give the case to somebody else. But like I say, my job is to evaluate these cases right now. Bottom line, our oath, everyone that's a judge, in fact all of you elected officials, we take an oath to follow the laws of the state of Texas, United States, and the two constitutions. And if we don't follow those oaths, if we're not protecting the law and giving fair trials, we got no business being in that job. Thank you.
And the question is this, and Wayne, you'll actually get to go first, and Lonnie, you get to have it last year. What do you see as the greatest obstacle to justice, whether it be civil or criminal, in our justice system now, and why is that a threat to justice? Wayne, you'll be first. 3 minutes, sir.
Of course, it's always very important for anybody who comes to court to be able to have an attorney represent them in the court proceedings. I think that Galveston County, on the criminal side, especially takes care of that problem because we have a court-appointed system. There's a vetting process that makes sure that the attorneys who are appointed on the cases, to the best of the judge's knowledge, are going to be qualified to represent the defendants in those cases. I would say, as a judge, the main thing I concentrate on when I hear any case, my focus is to make sure that I am very fair and impartial to both sides. I also want to make sure that I treat everybody that comes into my courtroom with dignity and respect. I think it is very, very important to treat everybody with dignity and respect. That way, even if you rule against somebody, as long as you're treating them with respect, they take that ruling a lot better. As long as you sit there and you listen to them, listen to what they have to say, listen to their case, and evaluate it according to the law, most people, even though you rule against them, are going to go out saying, well, the judge ruled against me, but at least he or she listened to what I had to say. And at least he or she treated me with dignity and respect that everybody deserves. But to me, it's always the main thing in my courtroom is to maintain that atmosphere where everybody is treated with dignity and respect. I think it's even more important to do that in criminal cases where you have people in your courtroom who are being tried on criminal cases, some of them violent offenses. You want an atmosphere where everything is calmed down as much as you possibly can calm it down. And you also want to calm the defendant down as much as you can calm the defendant down. And that's naturally done by treating the defendant with dignity and respect, no matter what he or she is charged with. Thank you.
Thank you, Wayne.
So many of us who run for judge throw the slogan around that justice delayed is justice denied. And one of the things that will hurt the system more than anything is to delay trials for whatever reason. And we have a lot of trials. We have a lot of cases at any given trial period, 2-week trial period, there'll be anywhere from 20 to 50 cases set for trial. So what do we have to do to make sure that cases get to trial in a reasonable time, because we have DNA reports or tests, drug testing that has to happen, discovery, videos that we have to gather so that both the defense attorney and the state can work their cases out, prepare the cases in the event that we do have a trial. And you've got to give defense attorneys and the prosecutors enough time to work their case, to prepare it, and sometimes to settle their case out, but not too much time. Right now, we're working on adding additional trial time for all of the judges. If we can add additional weeks for the judges to try cases, it's more work for the judges. But we need to do that in order to make sure that justice is not denied and not delayed. Thanks.
Thank you, Judge. Which of your past cases and your legal background as an attorney can you tell us about that demonstrates, since this is election season for the primaries, a conservative position, again, as an attorney and your legal background? Judge?
I'm talking more globally, not about one specific case. And speaking globally, I'm going to talk about our victim cases. Victims, not so much in victims of assault, but victims of theft, criminal mystery, personal property damage, those sorts of things. I'm a firm believer in getting up and going to work and working hard and earning every dime that we make. As a public servant, don't have very many dimes that we do make. So when we have citizens that come to us and tell us that they've been wronged, someone has broken into their home, they've stolen their car, they've gotten into their bank accounts or used their credit card information, and they've been harmed financially, my conservative take on that is very strong, and that we're going to fight that to the fullest, because I'm not a fan of theft, and I don't like the idea of any one individual giving their all to build something up and some other fool quickly coming and tearing that down. And so from a conservative approach there, as far as just dollars and cents, I mean, those are the cases that I think the strongest and the least tolerable in, because, in each victim, I think about myself and I think about my family, and I'm firm in that if it was me, I would want somebody to fight to the fullest. And that's why sometimes we get these state jail forgery cases, or state jail level theft cases. And some individuals may say, oh, that case is not really worth its salt. That case should not go to trial. I could not agree with that or disagree with that more. Those cases do, because the conservative in me says that we have to fight for those individuals that work hard to build their things up. Hope that answers your question.
Well, I was blessed to, as an attorney, to work for two very large international law firms where I represented businesses, everything from small businesses and business owners all the way up to Fortune 500 companies. As we all know, there's a lot of frivolous lawsuits where people want to sue for big money because they see someone with deep pockets. They don't have a case, but they feel like they can get something from the companies and from the people who built these companies up from the ground up. And my conservative values are absolutely that small businesses are the background of America. And for folks who don't work, aren't entitled to that money, didn't deserve that money, they're going out and suing these small businesses, these business owners who worked 100+ hours every week to build a business. And these folks come in and just want to tear it down because they want a buck. I saw that time and time again as an attorney, and I was proud to be able to represent businesses and in some situations save the company. We had some cases where that litigation could have absolutely destroyed the business owners and the company, and we were successful in making sure that didn't happen. So certainly, fighting against frivolous lawsuits, fighting against, there's some plaintiffs' lawyers are fine, but there's other plaintiffs' lawyers who we all know, what we call the ambulance chasers and that sort of thing, who are really don't have a case but want to just get a quick payday. And I had the opportunity to represent a lot of folks in defending against those cases. So I would say that really sets that out. Also, in doing employment law cases, you have a lot of folks who feel entitled to the job that they have, and that when they do a poor job, they don't work as hard as someone else, they don't think they should be fired, and so they want to sue the company for wrongful termination. So I've represented a number of companies, employers who were sued, for wrongful termination and things, when really all it was a lack of work ethic on behalf of the employee who was fired. So I think that represents a few different ways that I have represented folks in my conservative values for those cases. Thank you.
Thank you, Judge.
Ladies and gentlemen, thank you so much for your time and your listening ears on tonight. I'm asking for your support and for your vote in the March primary because I bring experience to the table. And equally, if not more important than the experience, I bring a judicial temperament to the table. Everything about me is based on life, it's based on family, it's based on making our county a better and safer place to live. I've gotten up for the past 5.5 years and done that tirelessly every day as working as a prosecutor at the DA's office. That experience I will bring with me to the table, along with the working relationships that I have with law enforcement, with prosecutors, as well as the defense bar. And I'm going to put a little bit on your shoulders and ask you to reach out to the people you know in the county and ask them about me. And I guarantee you that they're going to say, T. Philip Washington, while we may not always agree, he is fair, he is firm, and he is consistent. And that is what I offer to you as a judge.
Well, I certainly appreciate y'all being here and listening to all of us tonight. I will tell you, I would love to have your support and your vote to keep me as your judge of the 405th District Court. I've shown you that I have the qualifications, I have the experience, and I have proven to you that I'm efficient and effective and that I serve justice. So I hope that you will tell all your friends and your family to come out and vote for Michelle Slaughter for the 405th District Court. Also take a look at my website for some more information about me and the other folks who support me. Again, thank you, and I would love to have your vote.
I just go back to my opening statement. Again, the most important issues in this case are experience, judicial temperament, morals and ethics, and vision. Just to hit on experience, I am the most experienced candidate up here out of all of the candidates up here. 13 years with the District Attorney's Office, 8 of those as the first assistant. I helped run the office, supervise the attorneys, and prosecute the most serious cases that came through the office. Over 65 felony criminal jury trials, 20 of those murder and capital murder cases, 12 years as District Court Judge here in Galveston County, and 3 as a Senior District Court Judge, where I've developed a solid reputation of being a fair, impartial, hard-working judge who treats everybody with dignity and respect. I sure would appreciate your support and your vote to become the next judge of the 56th District Court. Thank you.
I'm the best educated judge in the county. I've got a bachelor's degree, but I've got a master's degree in business administration, and I'm board certified in criminal law, and there's only 6 of us in the entire county. My experience, in addition to being a judge, in addition to being an assistant district attorney, I have 16 years of business experience, which I get to bring to the courtroom because most of our cases, not most, many of our cases are civil cases, and that's the business world that we're talking about. So add the education, look at the experience, but let's check the attitude. And this is what you must know: I will stand up when other people will not stand up for you. I've been one of the longest running Republican judges in the county, endorsed by law enforcement throughout the county. And that's because they know that I will do the job of making the streets safe for you. I would appreciate your vote. Lonnie Cox, Judge of the 56th District Court.
Thank you, Judge.